protocols. I know that is the common saying. I'll just say I extend all courtesies. It is with great delight and deep sense of gratitude that I welcome you all on behalf of members of the Senate Joint Committee on Judiciary, Human Rights and Legal Matters and Anti-Corruption and Financial Crimes to this public hearing. May I also profoundly welcome our special guest of honor, His Excellency Senator Ahmad Ibrahim Lawa, PhD, CON, the President of the Senate, who, in spite of the very busy engagement of both himself and our principal officers, accepted our invitation to declare this public hearing open and ensured that a principal officer in the person of the Deputy Chief Whip, our most distinguished brother and colleague, Senator Abdullahi Sabi, is here in person. The presence of His Excellency here through his representative attests to the high premium the Senate places on this important legislative exercise. Once again, I thank you for honoring our invitation. Equally, I wish to warmly welcome all the principal officers of the Senate here present, as well as the sponsors of the bills. Permit me to also welcome our revered stakeholders, members of the public, and ladies and gentlemen of the press. As you all are aware, the importance of public hearings in a democratic setup cannot be overemphasized in view of its strategic importance to legislative deliberations on bills and other legislative measures before the National Assembly, as it is one of the most viable mechanisms the legislature utilizes in order to gauge public viewpoints on legislative activities. This is in realization of the fact that laws are made for the people, and any law made by the National Assembly must be people-oriented for it to be able to stand the test of time. It is on the strength of this that the current Ninth Senate, in line with its legislative agenda, deemed it necessary to conduct public hearings on bills and motions before legislative decisions are taken. Having said that, it is pertinent for me to state here that today's public hearing is quite a unique one. Unique in the sense that it is a single public hearing where 7 bills are lumped up together for deliberations. This decision was taken by the committee because the identified stakeholders are the same, and the need to also expedite action on the legislative process in order to keep with the time frame within the committee is expected to report back with its recommendations. For the benefit of hindsight, it is imperative to let you know that during debates on the general principles of the bills at the plenary sittings of the Senate, divergent views were expressed by distinguished senators on the provisions of the bills. This was also followed by the series of reactions from interested stakeholders and members of the public on the justification or otherwise for the passage of the bills as acts of the National Assembly. Consequent upon the above, the committee resolved to conduct a public hearing in order to collate inputs from stakeholders, which will form the bedrock of its recommendations to the Senate on the way forward. At this juncture, may I crave your indulgence to briefly comment on the intendment of the bills under consideration as a prelude to kickstart today's deliberations. Firstly, the Administration of Criminal Justice Act 2015 Amendment Bill 2021, SB 465. This bill was sponsored by Senator Orji Uzo Kalu, representing Abia North Senatorial District. The bill, in a nutshell, seeks to amend certain sections which the sponsor of the bill feels are in contradiction with the principles of fair hearing and to bring them into conformity with the provisions of the Constitution. The amendment is intended to make the Administration of Criminal Justice Act more effective and capable of producing socially desirable results, greater safety, and respect for the rule of law. In essence, the bill intends to avert conflicts between the Administration of Criminal Justice Act and the Constitution, which is the supreme law of the land. The second bill under consideration is the Court of Appeal Act 2013 Amendment Bill 2021, SB 670. This bill was sponsored by Senator Chukwuka Godfrey Utazi, representing Enugu North Senatorial District. The bill primarily seeks to amend the Court of Appeal Amendment Act 2013 by simply increasing the number of justices of the court from the present 91 and to 110 justices to allow for creation of more divisions of the court, appointment and elevation of judges from the lower courts to the appeal court, and bring the court closer to litigants in order to ensure speedy disposal of cases and to declog the docket of the court. The court also exercises appellate jurisdiction to the exclusion of any other court of law in Nigeria over decisions of lower courts. The third bill under consideration is the Terrorism Prevention Act 2013 Amendment Bill 2021, SB 662. The bill was sponsored by Senator Ezenwa Francis Onyewuchi, representing Imo East Senatorial District. The bill, among other things, seeks to amend the Terrorism Prevention Act 2013 in order to outlaw the payment of ransom to abductors, kidnappers, and terrorists for the release of any person who has been wrongfully confined, imprisoned, or kidnapped. The fourth bill is the Recovery of Premises Act 1945, Repeal and Reenactment Bill 2021, SB 746. This bill seeks to repeal and enact the Recovery of Premises Act in order to make a comprehensive legal and institutional framework for the recovery of premises in Nigeria. The bill clearly spells out the rights and obligations of both tenant and landlord in an elaborate manner for both parties to be alive to their contractual responsibilities by providing for stringent penalty for defaulters in their contractual obligations, in tandem with contemporary modern realities. The fifth bill is the Abduction, Wrongful Restraint, and Confinement for Ransom Bill 2021, SB 762. The bill was sponsored by Senator Ibikunle Amosu, representing Ogun Central Senatorial District. In a nutshell, the bill seeks to provide for stringent punishment for the offense of kidnapping by proposing life imprisonment for convicted kidnappers and 30 years imprisonment for persons who benefit from proceeds of kidnapping. The legislative intent of this bill is to combat and prevent any form of kidnapping in Nigeria by providing more punitive measures for kidnapping and other ancillary crimes, such as death or grievous bodily harm flowing from the commission of the crime. The sixth bill is the Community Dispute Resolution Bill 2021, SB 848. The bill was sponsored by Senator Sani Musa, representing Niger East Senatorial District. Essentially, the bill seeks to provide for a legal framework for the settlement of certain civil disputes through conciliation, mediation, and traditional dispute resolution mechanisms by setting out guiding principles applicable in Nigeria. According to the sponsor of the bill, effective dispute resolution mechanisms in our country will guarantee peace, which will invariably enable trade and investment that will contribute to the socio-economic and political development of this country. The final bill under consideration today is the Witness Protection and Management Framework Establishment Bill 2022, SB 641, which is a joint referral by the Senate to both the Senate Committee on Judiciary, Human Rights and Legal Matters, as well as the Senate Committee on Anti-Corruption and Financial Crimes. This is a joint referral between this bill was sponsored by Senator Sulaiman Abdul Kwari, representing Kaduna North Senatorial District. Basically, the bill seeks to provide legal and institutional framework for the protection of witnesses and related persons in respect of disclosures made for public interest. It also seeks to provide support, management, and protection of witnesses, which will be implemented by all public institutions vested with powers to investigate and/or prosecute criminal cases. Finally, I wish to conclude this address by stating that one of the ways we can consolidate and entrench a deep democratic culture in this country is for all the arms of government to work together in harmony in order to engender peace and prosperity that will meet the yearnings and aspirations of Nigerians. On this note, I wish to assure you that the leadership of the Senate, led by His Excellency Senator Ahmad Ibrahim Lawal, PhD, CON, is committed to effective partnership and synergy that will bring about dividends of democracy and development to our dear nation, Nigeria. And this can only be achieved through enactments of people-oriented legislations which are the bedrocks of strong and viral democratic society. On this note, it is now my pleasure and singular honor and privilege to invite the representative of the President of the Senate, His Excellency Senator Ahmad Ibrahim Lawal, PhD, CON, to give his keynote address and to declare this public hearing open.
Good afternoon. I am Senator Aliu Sabi Abdullahi. I represent the good people of Nigerian North Senatorial District. And by the special grace of God and the leave of my colleague, the Deputy Chief Whip of the Senate, I stand before you to stand in for the Senate President, distinguished Senator Ahmed Ibrahim Lawal, PhD, CON, Sardona Bade, who I believe perhaps they are just rounding up the plenary. Like the chairman of this sitting said, the importance attached to this public hearing is the reason why, of course, I have to be here to see to the work the Senate President ordinarily should be here to do. As it is, we want to thank you for coming, and I'll go straight in to read the speech prepared for the Senate President, which is basically what I need to do at this stage. Remarks by President of the Senate, distinguished Senator Ahmed Ibrahim Lawal, PhD, CON, at public hearing on 7 bills by the Senate Committee on Judiciary, Human Rights and Legal Matters. Let me say that all the protocols duly observed, and I want to stand on that. I am delighted at today's public hearing focusing on different areas of our judicial, human rights and legal system, as they are crucial proposals to strengthen our regulatory and governance mechanisms. The 7 bills before us include the Criminal Justice Act 2015 Amendment Bill 2021, the Court of Appeal Act 2013 Amendment Bill 2021, Terrorism Prevention Act 2013 and the Recovery of Premises Act 1945 Repeal and Reenactment Bill 2021. These bills are about serving justice or determining or deterring offenders. The Abduction Wrongful Restraint and Confinement for Ransom Bill 2021, Community Dispute Resolution Bill 2021, and the Witness Protection and Management Framework Establishment Bill 2022 seeks to grow our adjudication process, drawing from existing shortcomings. The bills are from the lessons we have learned from implementation, aside from the realization of areas needing fresh attention. While some are therefore about amendment and improvement, others are new. Whether new or old, they are geared towards increasing the capacity of the justice system, which is the basis for the stabilization of our democracy, leading to good governance and progress. The Senate has been exhaustive in discussing the bills, but now require the input of stakeholders. Your presence and expected participation is a natural flow of the legislative process in the quest for a logical conclusion. In looking at all the angles, we are preparing the grounds for longer-lasting decisions. This happens when thoughts are diverse, rigorous, and forward-looking, as a public hearing is one to guarantee. Because of this, your ideas are germane if you consider your diverse backgrounds and your depth of understanding of the issues on these bills, and our ability to harness these rich intellectual resources coming from the critical stakeholders here gathered depends on how these shortcomings will be. I am confident, however, that these sessions will be robust, going by your obvious enthusiasm and considering the elaborate preparations the Senate Committee has made for this event. As stakeholders in effort to grow our institutions, especially a critical arm like the judiciary, your special knowledge is not just valuable, but unique in the ability to set directions. Against this background, we look forward to having high-quality conclusions going by the high promise you hold. I therefore welcome you all once more, and on behalf of distinguished Senator Ahmed Ibrahim Lawal, PhD CON, the President of the Senate, it is now my pleasure to declare this public hearing open. God bless you all, and God bless the Federal Republic of Nigeria. End of quote. Thank you very much. I was just whispering to the chairman, considering the very important subject these bills are covering, honestly, I was expecting that there will be no space. But, you know, one thing the National Assembly has to re-emphasize is that public hearings are meant for people to come and give their opinions and their views. And I think when you don't take that opportunity, honestly, you do not blame the Parliament when a decision is taken. This is how open and transparent the Parliament is. But it's my belief that those who have been here, as I've seen here, are highly interested, and I think the quality of input that we will be getting, I'm sure, is the more what we need, rather than even perhaps the larger crowd that perhaps may be here. With these few comments, I thank you very much for listening, and I wish you a very successful public hearing. Thank you very much, and God bless.
General M.U. Wambai, MNI, the Director of Legal Services, Army, standing in here for the Chief of Army Staff, Lieutenant General Farouk Yahaya, Nigerian Army Medals. The Chairman, sir, I want to recognize my friend too, who was my classmate, distinguished Senator Suswan, who left, but I think he's coming back.
He's on civilian parade.
Invitation, and then for us to make our contributions on the 12th, but we've tried our best to make some input and submit it on the 14th to the Honorable Chairman. So at this, there's no time, as I understand that we were giving just few. I will just go into some of the important aspects of the amendments like for the administration of the Criminal Justice Act, 2015 Amendment Bill 2021, there's not much to be said, however, because the proposed amendment to Section 14, Sub 3 of the Administration of Criminal Justice assists to replace the words "shall be done in the presence" with the words "shall be done within the citing distance," because we look at it when you talk about the presence, and let there be opportunity given to the justices for them to determine the distance within which, the person should be investigated and whatever to determine, so that they will not be foul of the law. And then the word "shall" should be replaced with "may." To now read "may be done within the citing distance of." This will give the detaining officer in custody of the detainee, in this respect, the power to determine the circumstances to permit unrestricted communication between the detainees and other persons. It will also aid the use of eavesdropping devices during such communications. The circumstances here could include the nature of the allegations against the detainee, his or her criminal history, and the status of the visitor. It talks about who will visit a detainee and what is the distance between the detainee and the visitor. So if this is taken care of, it will go a long way. We have on the B part is the proposed amendment to Section 17 of 3, which seeks to include a new paragraph which reads, "Such an interpreter shall be at the instance and choice of the suspect held in custody." We know that the provision of an interpreter rests on the state. So it is better the state to be allowed to maintain when to provide an interpreter, rather than allowing, the suspect, to bring his own interpreter. So we have sent her to the chairman, and it will be looked into, I hope. So the Charlie part, the proposed amendment to Section 162 seeks to add the word "either orally or by a motion or notice."
Chairman. General, please.
Okay.
Yes, right.
So thank you very much.
Yes.
Then we have the Court of Appeal, which is so crucial to us. The Court of Appeal Bill seeks to amend the Court of Appeal Act 2013 by increasing the number of justices of the Court of Appeal to from 90 to 110. Having juxtaposed the bill with the Court of Appeal Amendment Act 2013, the Nigerian Army opines that the amendment of Section 1 of the Principal Act is in accordance with extant laws, and the Nigerian Army further advocates for the appointment of retired service personnel from the legal services of the armed forces to the Court of Appeal to serve as assessors. This is very, very important, because we have, like in the Sharia Court of Appeal, where the law is specialized, and so we need special people to interpret certain acts, certain provision of the act. We now request this committee to look into the appointment of assessors to sit down with the Court of Appeal justices, who will bring the wealth of their knowledge, when it comes to matters of military law. It is very, very important, and we hope this will be looked into. The Terrorism Prevention Amendment Act and all other bills, as we have forwarded our inputs, we just hope the chairman will take care of them. Thank you very much. General M.U. Wambai, MNI, the Director of Legal Services, Army, standing in here for the Chief of Army Staff, Lieutenant General Farouk Yahaya, Nigerian Army Medals. The chairman, sir, I want to recognize my friend too, who was my classmate, distinguished Senator Suswan, who left, but I think he's coming back.
He's on civilian parade.
invitation and then for us to make our contributions on the 12th, but we tried our best to make some input and submitted on the 14th to the Honorable Chairman. So at this, there's no time, as I understand that we were giving just few. I will just go into some of the important aspects of the amendments, like for the administration of the Criminal Justice Act 2015 Amendment Bill 2021. There's not much to be said, however, because the proposed amendment to Section 14, Sub 3 of the Administration of Criminal Justice Act is to replace the words "shall be done in the presence," with the words "shall be done within the citing distance," because we look at it when you talk about the presence, and let there be opportunity given to the justices for them to determine the distance within which, the person should be investigated and whatever to determine, so that they will not be foul of the law. And then the word "shall" should be replaced with "may." To now read "may be done within the citing distance of." This will give the detaining officer in custody of the detainee, in this respect, the power to determine the circumstances to permit unrestricted communication between the detainees and other persons. It will also aid the use of eavesdropping devices during such communications. The circumstances here could include the nature of the allegations against the detainee, his or her criminal history, and the status of the visitor. It talks about who will visit a detainee and what is the distance between the detainee and the visitor. So if this is taken care of, it will go a long way. We have on the B part is the proposed amendment to Section 17 of 3, which seeks to include a new paragraph which reads, "Such an interpreter shall be at the instance and choice of the suspect held in custody." We know that the provision of an interpreter rests on the state. So it is better the state to be allowed to maintain when to provide an interpreter, rather than allowing, the suspect, to bring his own interpreter. So we have sent her to the chairman, and it will be looked into, I hope. So the Charlie part, the proposed amendment to Section 162 seeks to add the word "either orally or by a motion or notice."
Chairman. General, please.
Okay.
Yes, go ahead.
So thank you very much.
Yes.
Then we have the Court of Appeal, which is so crucial to us. The Court of Appeal Bill seeks to amend the Court of Appeal Act 2013 by increasing the number of justices of the Court of Appeal to from 90 to 110. Having juxtaposed the bill with the Court of Appeal Amendment Act 2013, the Nigerian Army opines that the amendment of Section 1 of the Principal Act is in accordance with extant laws, and the Nigerian Army further advocates for the appointment of retired service personnel from the legal services of the armed forces to the Court of Appeal to serve as assessors. This is very, very important, because we have, like in the Sharia Court of Appeal, where the law is specialized, and so we need special people to interpret certain acts, certain provision of the act. We now request this committee to look into the appointment of assessors to sit down with the Court of Appeal justices, who will bring the wealth of their knowledge, when it comes to matters of military law. It is very, very important, and we hope this will be looked into. The Terrorism Prevention Amendment Act and all other bills, as we have forwarded our inputs, we just hope the chairman will take care of them. Thank you very much.
Very brief. I commend the opportunity to Barrister Mwakeze Emmanuel. I'm Controller of Corrections in charge of custody at Nigerian Airforce. I represent the Controller General of Nigerian Correctional Service, Haliru Nababa MNI, who is unavoidable absent, and he extends his greetings to the honorable members of the Senate and other colleagues around. We thank the people who made various contributions, and some of them had already presented our position, but I will just briefly look at one or two. In most of the, I will start with the Criminal Justice Act, in which we agreed with most of the amendments, but we disagreed with two. One of the ones we disagree with is when it's talking about when somebody is charged an offense and then he gets another offense, in the process another crime was discovered. We don't feel that that in any way infringed on the right of the fair hearing and the impartiality of the court. The person will be charged on another charge, additional charge, which even here and here we can make an additional input. So there's nothing wrong as far as from our own position that the person, maybe is charging him for stealing a car and it's discovered that he killed somebody. Then you add the charge, and that has not in any way affected the impartiality or his right for fair hearing. So I want the distinguished senators to look at it again and the members that to look. And then secondly, the issue of even when a judge is elevated, we have a different view. We believe that the same judge that was elected can also be appointed by his state to come and do a special assignment. Why not let's look at it in the amendment that this man, after when he's elevated, he takes this one as a special assignment than starting the novo. For those of us who are lawyers, we know the harm, the setback it puts on most of the cases. Maybe you almost at the address system or you have reached your address, the judge is elevated, you start the novo. Maybe another person after some, the other man is transferred, he starts the novo. Some of the cases, that's why some of the cases last up to 10 to 20 years because of this. So we have opportunity to look at it. I'm happy somebody said that can be amendment through the Constitution. But I didn't see in the Constitution where, because the sections quoted in the Constitution in this, the person who proposed the bill, so didn't see where it actually, it was not stated there. But I don't know where, I read the sections that are provided and they have nothing to do with. But that's not, let me go to that of a Court of Appeal. That is a very beautiful amendment, and justice overdue, and will go a long way in enhancing and fast-tracking justice delivery. So it's a very good bill. The other Terrorism Act, we agree with some of the amendments there, but that of recovery of premises, we are not able to actually do much because we got this in yesterday. But despite that, we are able to submit. We have submitted our position. Without wasting much of your time, I want to thank everybody and let us continue to make progress. We appreciate the senators for the work they are doing for the nation. Thank you, and God bless everybody.
Gentlemen of the press, what is left, I guess, is to once again appreciate you for your patience and for being a part of this very important legislative process. I want to also urge all stakeholders to be rest assured that the Secretariat has copies of your submission, as well as the Secretariat has taken due notice, and all of us are taking due notice of your various rounds of adumbration that you have done here today, trying to expand further on what you submitted. And for those of you who also asked for time, that's also granted, till next week before we finalize our report. As you know, the essence of public hearing really is not for us to push our own position. It's for us to be able to listen to members of public and stakeholders so that at the end of the day, our committee will be able to analyze and harmonize the various positions, and then we'll be able to prepare a report that will lay on the floor of the Senate for final consideration. But be rest assured we will do justice to the issues you have raised, and the positions you have canvassed. Once again, I just want to thank you, and I wish you the very best of this evening and what is left of the week. God bless you.
Come.